Welcome to another Lunch and Learn session. And today we will be discussing how and when to refer a maintenance inquiry to court for a formal Section 10 inquiry. And joining me today is Advocate Reuters. Dion, welcome again. Thank you so much for joining us.
Thank you, Eugene, and welcome. I hope our listeners will be able to learn something new today.
Absolutely. Well, if we're here, then they're up for some learning, most definitely. So today, like I said, we will be discussing the Section 10 inquiries. So we will say, what is a Section 10 inquiry? What is the procedure to have the matter transferred from a Section 6 inquiry to a Section 10 inquiry, about the wording of the Act that says, what the maintenance officer does have a discretion in referring the matter. We will talk about the duties of the maintenance officer as well as the judicial officer, the magistrate sitting in front. What are their duties when it comes to a Section 10 inquiry? Also, Advocate Reuters will take us through some of the recommendations that the maintenance officer could do to court pertaining to a Section 10 inquiry. And then as well, lastly, we will touch on aspects on, how do we get the parties to court? How do we issue the Section 9 summons, and what are the consequences if those parties do not appear in court? So just for our attendees, for all the people that registered, thank you so much. Our numbers have been growing quite exponentially, which we are very thankful for. And it just shows that there is definitely a need out there for education. So those that have registered would have access to our web portal, where you would have some pre-reading material. If there's any pre-reading material, that will be in the pre-reading folder that you would find on the website link that has been sent to you, as well as obviously the live webinar. And then most importantly, the resource and templates folder, where we will copy in all the documents that we're referring to during this session. All the case law that we are referring to will be copied into that section. So without any further ado, like I said, what is a Section 10 inquiry? And we all know from past webinars that the Section 6 inquiry is the informal inquiry in court or in front of the maintenance officer, and the Section 10 inquiry will be done in court, which is a little bit more of a formal process. Dion, just some intro words from your side pertaining to the Section 10, just in broad terms. What is your view on the Section 10? Where does it fit in? What is the place of a Section 10 in the whole maintenance process?
Okay, the Section 10 is, as it says, it's not the informal process that is happening in the Section 6 in the maintenance officer's office. But now we are getting to the real court, where the magistrate are involved in. So in most cases, the Section 10 will happen in the magistrate's court, in the big court, where the magistrate will then get involved. And that usually happens in a case where there is not a consensus or an agreement between the mother as well as the father and the legal attorneys, in case they have got legal representation in those cases. But it usually happens after the Section 10, no consensus is reached, and the maintenance officer make a recommendation that the case be referred to a magistrate for a formal Section 10 inquiry.
Because the formal Section 10 is then done in court. We all know that the whole maintenance process is considered to be sui generis. It's unique in nature. So it's not criminal, and it's not civil, but it does have the elements of a civil case, a normal civil case. And specifically when it comes to the Section 10, because it's done in court, there are certain court processes that needs to be followed.
Yeah. That's true, and that's all being governed by Section 10 of the Maintenance Act, where it then also indicates that the law of evidence applicable to civil proceedings are being used by the magistrate during those proceedings. And that's why over the years degenerated into all of these bundles that some courts are requesting, which I do not so much subscribe to, especially in the case where the applicant and the respondent are in person. I just don't believe that it should be so formalistic with the bundles and all of it. But the civil process are the process that are being used. The applicant will testify first with all her documents, and then after that, if she's got witnesses, then they can call these witnesses, or the maintenance investigator will testify, followed by the evidence of the respondent and his witnesses. So that all forms part of the magistrates' court rules, as well as the civil proceedings that are being utilized during the Section 10 proceedings.
And just on that point, although it's very civil in nature, there's no need for legal representation. People can, or mothers or complainants can actually conduct their own case. That's true.
Yes. In most of these cases, a mother do not have to incur further financial cost in order to employ the services of an attorney. She can do it on her own, and she is supposed to be guided by the maintenance officer as well as the maintenance clerk in what is necessary. That both maintenance clerk, maintenance investigator play an active role during that process before the Section 10 is going to start. So they will tell the applicant what information they need and what information they need to put in front of the court. So she will then be able to know what she needs to provide to the court in order to get to the quantum that she wants.
And that's why they say the whole proceedings in terms of Section 10 is inquisitorial of nature, and there's actually a duty of the maintenance officer to assist unrepresented parties, and even the magistrate. And I mean, I'm thinking of two cases, Buch versus Buch and the Beekers case, where the courts actually mentioned and said that although they are legally represented, irrespective if both of them or only one of them have a legal representative, that the court needs to play an active role in establishing obviously it's all for the benefit of the child, but they need to be actively involved in the calculations and getting evidence, putting forth evidence to court to make an informed judgment call regarding the maintenance of the child.
That's so, and I think we're going to do a lot of cross-referencing to Beekers as well as Buch further on during our discussion. That these magistrates cannot sit back and just be a rubber stamp of what's happening and just make a court order. They are obliged in terms of case law to play an active role in coming to whatever amount or quantum is being decided on.
I can just mention that I've been in court quite a number of times. We for a Section 10 inquiry assisting clients, and then the magistrate would say, "Okay, right, Mr. Opperman, you may proceed." And if it is a civil proceeding, a civil trial that I need to conduct my case, and in effect, it's not true, because not one side has got the onus of proof. It is shared by both parties, because all the documentation, everything, all the evidence needs to be put in front of the magistrate, and they also need to play an active role with regards to that. But very often, especially when there's legal representation, then the magistrate would take a back seat and they would say, you know what, okay, right, now you conduct the sessions, which is not the correct way of doing so.
Yes.
Just tell me about the full disclosure of the parties. What means are there to ensure that there is full disclosure between all the parties? Obviously, the respondent as well as the complainant.
Well, the legislation says there must be full disclosure, but in most cases, there isn't a numerous clauses of what is a full disclosures. But what I try to do in the Western Cape is I try to introduce the financial disclosures form that is used in divorce proceedings in Gauteng. And some of my colleagues are using it, not all of the 57 courts. But hopefully later this year, I saw that the Law Commission has shown a keen interest in making this financial disclosure one of the J forms of the Justice Department. So hopefully there will be more clarity on what should be provided. But in most cases, it will just be the normal salary slips, bank statements, and those are the type of things that the maintenance officer will require from the respondent. And once he's got those documents, then the inquiry can start. And as they proceed during the inquiry, then the maintenance officer will indicate what other documents is necessary in order to make a full financial disclosure, including number of cars are registered on your name in terms of e-notice, or your ITC, where you've got credit agreements. All of those type of things can also be done or investigated by the maintenance officer. But
shouldn't that, isn't the whole idea of the Section 6 inquiry to gather all that information, that you have all that information ready when you do a Section 10 inquiry? That surely would be the aim of the Section 6 inquiry, and if parties cannot resolve it there, to go to a Section 10. But the court does have the leniency and the power to say, but you know what, this is transpired through evidence, and this is what we need additionally, and then the matter would be postponed.
Yes, excellent. That's completely correct. It will obviously already have been investigated, but out of in practice, what I've realized is that the respondent will just give what is being asked and nothing more, even though he knows that he's got some other financial interest. And if it is not the applicant that give us that information, but actually he's got a spaza shop over there at his house, or actually he's got an Uber business, he will not give any of that information. So it's important that applicants that are online and listening to us, please, you are the source of information. You need to give us that extra information that might be necessary. Else, the maintenance officer will just work with the bank statements, the credit card statements, and e-notice, ITC, all of those things that have been gathered during the Section 6. But we need to guide them as far as what other financial interests are there, because I haven't ever heard in my years of experience of a respondent that said, no, but sir, I also have another financial interest there, or whatever the case might be. That will never happen. So I will alert the applicants, please be alert during that process, where you can play an active role in making sure all the information is gathered by the maintenance officer.
And that is all given to the maintenance officer prior to the Section 10 inquiry, of course.
Yes, and if I can also ask that they, in a case where they are aware of some of these information, please make it known to the maintenance officer, or email him and ask that we investigate it, and why it's important to investigate it. Don't just say that they need to investigate X, Y, and Z, or the girlfriend's accounts, because it's not going to be done. There must be a reason why it's being done, in order for the investigations to then go as far as investigating a third party's account, or finding out his interest in a partnership, or whatever the case might be. So they need to guide us as far as what other information or financial interest that is important that we can use during the Section 10 inquiry.
And obviously, only once a legal liability to pay maintenance have been established. So that is now, paternity is out of the way. So he is the father. Only then the parties can actually be obliged or compelled to give evidence. What would happen to a respondent that just come to court and they just refuse to say anything?
Well, if they can't refuse, because in terms of Section 39 of the Maintenance Act, if any person in any way hamper or don't contribute to and obstruct the inquiry process, then obviously there will be criminal consequences where he can even be prosecuted for obstructing that specific inquiry. But he will have to actually participate and give his full cooperation during that time. If I just can quickly, on the legal liability, I found over the years that it's not in all cases that they ask about paternity, and I'd like our viewers online to please make sure that in a case where a maintenance officer do not ask the question on legal liability and paternity, that they ask, please ask him if he accepts that he is the father of the child, so that we have that on record. Because as soon as this specific respondent have a new girlfriend or wife, then all of a sudden then the child is not his child anymore, and they become medical experts in the field of
DNA.
paternity. So before it comes to that, mothers ask that question. Tell the maintenance officer, please establish paternity. He must say whether he is the father, and make a note over there on the court record that he accept paternity, so that it won't become a problem 6 or 10 years from now when he's got a new girlfriend or a new wife, that they all of a sudden become experts and want to say it's not his child or whatever the case might be.
And then of course, also to prevent the cases being postponed endlessly for DNA testing, because now he disputes paternity and the matter needs to be remanded, and then he doesn't have money to pay for the DNA test, and then it's be remanded again, and then the poor complainant sits there without any recourse whatsoever. So in order to address paternity as soon as possible, even during the Section 6, or preferably during the Section 6 inquiry, before this court inquiry, the formal one, is actually advisable.
That's true. And what is happening in our courts is, last time we spoke about in the Section 6 about the confirmation of paternity form. That form is not being used uniformly by all 57 courts in the Western Cape, as well as the other courts other maintenance courts in South Africa. And I wish we could get to a point where we get paternity sorted out right in the beginning, then you won't have Section 21 DNA test later on during Section 10 proceedings. Section 10(6) says this matter must be sorted out, the maintenance matter must be sorted out expeditiously, and the number of postponements must be limited. Now a case is postponed for 6 weeks for paternity that should have been sorted out in the Section 6 already. So to avoid that happening, it's important that we get all of these legal liability questions sorted out as soon as possible to ensure the Section 10 is not going to be hampered by unnecessary remands or unnecessary postponements just for DNA paternity. Then in Section 10, there should not be any question about paternity.
Correct. I totally agree. Right. So what is the procedure then, and when does the inquiry actually go to court? When is it transferred from a Section 6 inquiry to a Section 10, the formal one?
Okay. Yeah.
Sorry, no, you can proceed.
Okay. All right. So in most cases, it will happen when there is no consent order being drafted, or where there is a dispute between the parties pertaining to the cost involved or the expenses of the child. That is usually where there might be a problem as far as interpretation is concerned. What is necessary cost? What is unnecessary cost? What's the unnecessary expenses? And that is where the respondent will, in most cases, not agree, or why the applicant will say, but it's important for her child to also go for aftercare lessons or for extramural activities, which the father is not willing to pay or doesn't agree to. And that is some of the main issues that usually lead to Section 10 inquiries, is those
so there's a
disputes
dispute regarding money. So it's all about,
yes.
it's all a dispute about money. Just another question that just
Yes.
popped to mind. I've seen many of the attorneys, some of my colleagues, with some force and some conviction, they insist that the maintenance officer refer it to a Section 10. But in actual fact, it is not their choice. It cannot be on the application of an attorney. The sole discretion for transferring matter from a Section 6 to a Section 10 is solely the responsibility of the maintenance officer.
Yes, Section 6 is clear. The last section in Section 6 says that once the investigations is done, the maintenance officer may refer the matter to the magistrate for Section 10 inquiry. And the word is may. It doesn't say there's an obligation or must take it to a Section 10. So the maintenance officer have the final discretion whether it should go to a Section 10. And attorneys can't under any circumstances force or compel a maintenance officer to enter into a Section 10 inquiry in a case where the maintenance officer can show that these are the expenses. The expenses are all gone to, and they agree on the expenses of the child, and whatever their means are, there is an agreement on whatever their income or their means are. And there's no need for any matter to go to a Section 10, especially if the expenses are clear and the income potential of both parties are made clear. Then there shouldn't actually be a Section 10. But unfortunately, in some cases where attorneys are involved, then it becomes a little bit more difficult, and then it, in most cases, culminate into a Section 10 inquiry.
Section 10, yeah, totally agree. I just want to come back to and you alluded to that, and the case of Young versus Young, where it says that when, even after the maintenance proceedings have been instituted, so even during a Section 10 inquiry, if the parties come to some kind of agreement and they want to withdraw the proceedings, so with other words, they don't want to proceed with the Section 10 inquiry, or they want to have the terms of the agreement that they've just reached to make that an order of court, then the court cannot disregard that. The court must listen to that. Because yes, we all know that, you know what, for most people to go to court, it's not like you and I that are on courts every second day. And that's basically an extension of our office. But it's daunting for people going to court. And very often we see that, you know what, they're full of bravado, and they, you know what, they want to fight it in court. But as soon as they get to the court, then they settle the matter. So it is possible for them that even during the course of the proceedings, that they can make an agreement, and then it could be reduced to writing. And in terms of the case law Young versus Young, they could do a consent order or ask the magistrate then to make an order, and that would be the final order, the agreement that was reached between the parties without the court's further intervention.
That's precisely true, and that's why I keep on, or I'm advocating for Section 16.2. Any court can make that order. If there is the offer or the request from the applicant that she wants X amount, and the respondent offer Y amount, and the applicant agree to it, then there's no reason why we should have a long protracted maintenance inquiry, all of those things. If the parties agree to it, even though the Section 6 was concluded and then a Section 10 date was organized, and in between they came to a conclusion, well, I'm not going to waste any further time, I will accept the offer that was made by the respondent, there's nothing that stops the court from then, in terms of Section 60, reduce that agreement between the parties on a J168 court order form. And that is all that needs to be done. I think in South Africa, we started to make this intricate ourselves by expecting it now to run the whole process. But luckily, Young versus Young 38 years ago already made it clear. So hopefully, shame it's a long time ago, some of these Mr. Young's children are now adults by now, but at least the case law or for the Western Cape have been sorted out. So the Western Cape have case law pertaining to the process, especially after Section 6, and the respondent comes with a new offer that is accepted. Then why can't we J168 make that a court order?
Absolutely, totally agree. Just in short, what is in your own words, couple of seconds, minutes, what is the main difference then between the Section 6 and the Section 10? I just want to bring that in because some people have been listening and they've been following the process, and we've talked extensively about the Section 6 inquiry, and now we've got the Section 10, and in their mind, it might seem similar. What are the main differences between these two sections?
Okay, for me, the main type of difference is some people call the Section 6 not a Section 6 inquiry, they call it investigations. And I also believe that it is an investigative inquiry more, because during that time, all the investigation is being done. The maintenance officer collate all the information, get all the bank statements, get all the ID documents, birth certificates, all of those things are being done during that period. So that's the investigative inquiry. And once all of that is being done and collated by the maintenance officer in conjunction with the maintenance investigator that do the investigations, that is when the maintenance officer will make his recommendation. But initially, the maintenance clerk, maintenance officer, and the investigator play that pivotal role in making sure all of the information is collated and gathered. And then once he's got all of the information, the maintenance officer will make that recommendation in terms of Section 6 of what he have on paper, what he think is in terms of Section 16 a fair and equitable amount that can be claimed for maintenance based on the information that was being brought before him. If they do not agree to it, then it becomes the formal inquiry, meaning all investigations that would have been done by then, and now we are only dealing with the evidence before us. And some applicants make the mistake of thinking, no, I will keep this information until we get to the magistrate. Don't ever do that. You are busy hampering your own case, because then it will, yes, it can be remanded just because you want to wait till you get to the big court.
Okay, so we've got the Section 6 inquiry that has been done previously to that, and then we come to the formal court, the Section 10, and obviously the rules of evidence apply, and that would actually lead to the applicant that needs to testify, and then the respondent that needs to testify together with the witnesses, but they would also be cross-examined on what they say. So which is a little bit different from the Section 6, is that you will be sworn in by the magistrate by giving evidence under oath. Yes. And then you would obviously have the opportunity to be cross-examined by the opposing counsel, and you will also be able to cross-examine the respondent on their income and expenditure. And then the maintenance officer, maintenance investigator, or anyone that needs to testify would testify, and then the magistrate, the judicial officer sitting in front, would make a decision regarding the fair and equitable amount, as you've mentioned, regarding to maintenance. That's in short the Section 10 inquiry, the process.
Yes. And what I can also just add is one thing that I found that the maintenance officers make a mistake is the Section 6 have equal value as a Section 10. And what I always do whenever I do a maintenance inquiry, I swear my witnesses in front of me, because in terms of Section 34, I can prosecute them for false information. So if there's Correct. False information that is being provided during my inquiry in my office, then I can charge it, but only if they were sworn in. So I always will swear my applicant in and my respondent, and I warn them, if they give any information in my office, I can prosecute them. Some have the idea that it's only when it gets to Section 10 before the magistrate, and the magistrate doing the swearing in, then it becomes where we can file a charge of perjury or providing false information. You can even do it during the Section 10 if you properly administer the oath and the swearing in process. If you do it there, then you can then file a case in case there's false information that was provided.
That's not for the Section 6 inquiry. That's not during a Section 6 inquiry.
During the Section 6, yes, if there's false information given there, we cannot prosecute unless he was sworn in and made aware of his rights during that process.
But surely the J101 form that we need to fill in, the application form, is also done under oath. It's
Yes.
also it's also deposed to under oath. So then you would
Uh,
have, what if and that's usually what us as attorneys do, is that what we scrutinize what has been said in court, either a Section 6 inquiry or a Section 10, and then compare to that to what was said during the J101 form. And we would actually roast the respondent or the applicant. It all depends on who you act for, on specifically contradictions in their testimony, because both was under oath.
That's completely true. But Eugene, if you one day ask an applicant how many of them actually swore and that commissioning was of the J101 or the
Was
J107 was
properly done.
done,
Never. Yes, I
no
totally
one,
agree.
because
I totally agree.
because
I totally agree.
and that makes
I've seen clerks of the court, clerks of the civil court, just take the forms, just stamp it, without uttering the words that what they understand the contents, whatever. They just
yes,
stamp it and they just give it back. So it
yes.
has actually diminished the whole idea of giving evidence under oath.
Excellent. And the value of that document is completely
Correct.
diminished just because of not properly administering the commissioning of that document.
Just to circle back to something that you've said earlier, is that it's not necessary in all circumstances that the matter will be transferred to a Section 10 inquiry, especially if the expenses of the minor children are not in dispute, or the income of the parents are quite fixed. Then it is not necessary to refer the matter to the maintenance court in terms of Section 10. Just
Yes.
briefly tell me about the duties of the maintenance officer, because the maintenance officer is the only constant. They've been coming from the Section 6 inquiry, now moving through to the Section 10 inquiry. What are their duties specifically? Make mention to the summons, the way that they get the people to court, or the applicant and the respondent to court.
Okay, so in the case where the Section 6 is now done and it goes to a Section 10, then we would use the provisions of Section 9.2, and we summon the applicant and the respondent on a Section 9.2 summons. Even in a case where both of the parties are at court, and the Section 6 date is being made known to all of them, the applicant is respondent can request that Section 9.2 summons be issued unless they have been warned by the court. If they were warned by the court, a Section 9.2 summons is immaterial, it's not necessary. A reason being is in case of a default order on a J252, if you would like to get a default order to be issued, then in terms of Section 18, it can only be done in a case where a Section 9.2 summons have been issued. It cannot be issued when a Regulation 3 directive that is being issued during the Section 6 have been issued, and the parties have been warned by a maintenance officer, not by the court. Then the court will not be able to then give a J252 default order, because it was not a Section 9.2 summons that was issued, and the maintenance officer warned the parties in his office. They need to be warned by the court in order for the provisions of Section 18 to be applicable, and that a default order be issued.
Okay, and tell me whose responsibility is the service of the Section or Section 9.2 summons? Whose responsibility is the service thereof? Because people might confuse this now with they get a letter to give to the respondent, which is usually a Regulation 3 directive in the previous one, the Section 6 inquiry. But the Section 9.2 summons is more a formal court document, a prescribed document that formally needs to be served upon the parties. It's not like it's not an informal Regulation 3 where the maintenance officer could actually just phone up or send a WhatsApp or whatever to the respondent. But then Section 9.2 is much more formal in nature, and it needs to be properly served. So who does that service of that document?
Yes. In the case of the Section 9(2) summons, as you correctly pointed out, the empowered officers at the back of the Section 9(2) summons is only a maintenance investigator, a police officer, or the sheriff of the court that can issue that document. In this specific case, the Section 9(2) summons cannot be issued by a maintenance or cannot be served by a maintenance officer. It cannot be faxed to a respondent. All of those things that we can easily get away with the Regulation 3 directive in the Section 6 inquiry is not applicable in the case of a Section 10 inquiry. There we only use the Section 9(2) summons.
That's why it's also important. That's also why it's important for the correct details to be filled in the J101 form, because there's a portion there that asks you for the police station closest to you,
Yes.
and the correct police station closest to the respondent, so that
Yes.
the maintenance officer would know where to issue that summons on both the applicant and the respondent.
Yes, and in most of those cases, the Regulation 26 only makes provision for when it's being served by the sheriff and the respondent is not at home. The only other way you can serve it is by fax. Email service is not being allowed in terms of the Maintenance Act or the regulations. Substitute service is in terms of the Magistrates Court Act, but it is not explicitly provided for in the Maintenance Act or the maintenance regulations.
But it's not excluded. It's not excluded. One could use that if you have legal representation, they bring an application for substitute service. That is quite possible to do that.
Yes,
although we don't see that quite often.
Yes, but then in terms of Regulation 9, you have to show that there have been concerted effort in order to see how that you tied the police, you've tied the maintenance investigator, and you've tied the sheriff to serve it, and none of them could serve it properly on him. Therefore, you are approaching the court for a substitute service. Then it can be done that way. You're correct.
Correct. Dion, tell me about the recommendation that the formal recommendation that the maintenance officers do. They some of them do that, some of them don't. The Act does not prescribe formally that it should be done or it should not be done in a certain way. I know in the Western Cape, and I mean the people that you train them to do the recommendation, which is absolutely brilliant, because then it just takes off the burden from the courts, and it emphasizes that the maintenance officer was actually actively involved in the whole process of establishing the maintenance amount. Just talk me about about your feelings about the maintenance recommendations.
I advocate in the Western Cape that we get a recommendation on paper. So in case something goes wrong and on a specific day, the maintenance officer is sick or involved in an accident or halfway dead or whatever the case might be, then at least there is some documentary proof of what work he has done. And there's nothing that stops that proceedings from going on. The hundreds of inquiries that I've done, I always try and reduce it to writing and making sure that a copy of it is in the maintenance file. So whoever else is going to deal with that matter will see where I left off. So then there will be someone else that will be able to easily take up my file that I've worked on and continue it. And I'm trying to advocate in the Western Cape that the maintenance officer do that.
And it also speaks to proper record keeping, as the Act requires, that they have to keep proper records. So if you have the recommendation, because they see 100 people a day or a week, that they could actually know what it's all about because they've got everything on paper.
That's true. The Regulation 24 as well as Section 42 is clear. We need to make sure that there's proper record of it. And what I've seen happening in some courts is the maintenance file is riddled with dates in front. But when you look in the file of what happened on a specific date, there's absolutely no record of what is happening.
Correct.
And that is unfair towards that maintenance applicant that have been to court and would have give a report of what happened, but there's no corroborating proof in the specific file. That's why it's important that a maintenance officer write down every single detail of what is happening in the maintenance inquiry, or even if the inquiry is postponed, there must be a record of what happened during that
And why
specific
it
date.
was postponed. Yes.
Yes, and
Correct.
that date that is on the maintenance file, there must be a corresponding piece of paper indicating what happened on that day. I'm in favor of a recommendation, and the recommendation doesn't have to be a whole 10 pages like mine is. It can be a 2-pager just saying that I've looked at the expenses. These are the expenses that are being agreed upon by the applicant and the respondent. I found that the means, after I asked them, the means of the respondent is his income earned there. The applicant's income, she confirms, is whatever the amount is. Therefore, my recommendation is it can be a 1-pager. It doesn't have to only expenses of the child, what is the means of the parties, and what is a fair and equitable amount according to the maintenance officer. That's
and that
it.
would also assist the judicial officer, the magistrate sitting in front, reading through the documentation, because we notoriously know that magistrates don't like doing maintenance. Very seldom they like doing maintenance. So if you can give them the information beforehand with, this is what's going to be testified about, and this is my recommendation, that would actually be very much beneficial to the applicant, as well as the lady magistrate, of course, but it would be very much beneficial to the applicant. Do you want to tell me about the bundles? You've mentioned that earlier. You don't like the whole idea of bundles, and it seems daunting for so many people. They don't understand what it is, what is expected.
Yes.
What is a court bundle? You and I know because we work with it each and every day, but most of the listeners out there would not know what it is. What is the court bundle that is referred to, and why is it necessary?
So the court bundle is a lot of documents that some magistrates request that it be in an indexed form, and especially if applicant and respondent is unrepresented, I don't feel that we should be so prescriptive with the index bundle. But the bundle will consist of the J101 or J107, as well as the supporting documentation on why the applicant is requesting X amount. Those are the documents that will be in that specific bundle. But because of the way maintenance have been dealt with over the years, magistrates have become more prescriptive as that it must be an index bundle. The maintenance officer must show the the applicant and the respondent how to complete the index bundle. And I just feel it is unnecessary, and it just is a waste of time. All if the maintenance officer did his work properly, the magistrate should play an inquisitorial role. Okay, so if you've done all your work, what is the expenses that is agreed on? What is the means of the applicant? What is the means of the respondent? So what is the issue? What is the thing that you differ about? Let me then probe that. Instead of going to all of it that happened in the Section 6 is just being
because otherwise it would just repeating it all over again. And the Section 10 is not a duplication of the Section 6. It's actually certain points that was not agreed upon that could be argued in court in terms of Section 10.
That is the only thing that should be dealt with, not a repetition of the whole Section 6 again. It's state money that's being lost in the process because the maintenance officer is doing the same job over again in Section 10. It's a waste of time. Just focus on what is the issues that they are not agreeing on. You already have a history of what happened in the Section 6, so now let's move on. And now they want these bundles, index bundles that have been listed as all the documents and page numbering. I just feel they make it unnecessarily complicated. It could be so much easier. And Section 10.6 is clear. We need to limit these postponements, and then it becomes, because the bundle has not been submitted, therefore the cases are remanded, and it wastes time.
Mm-hmm. Totally unnecessary. And I mean, the whole idea of court bundles is also very much pertaining to civil procedure. That's more a full-on civil procedural process that needs to be followed, and it's not necessary in the maintenance courts.
Yes.
Dion, the discussion you've discussed now the Section 9 summons in court. Just what happens if the respondent does not appear? He received the Section 9(2) summons and he does not appear in court. What is the remedy? What could the applicants expect?
In a case where the respondent doesn't appear and he was formally summoned and there is a proper return of service, then there is no reason why a J252 default order cannot be issued by the magistrate in that specific case. Then the court can issue a default order. What is important for our online viewers is they need to make sure that if they know their case is next week, call the court and find out if there's a proper return of service. Else you're going to waste your time going to court and then just get a new date of whatever the new date is. I say we'll issue another Section 9(2) summons. If you go to court, make sure you know your rights. If a Section 9(2) summons was served and it was properly served, there's no reason why the court can't issue a J252 default order.
Perfect. And we'll definitely be discussing the rights and recourses in future webinars. What is the rights and what is the recourses in terms of maintenance? Okay, so how does the court decide? Like we've mentioned, there's no burden of proof. So there's no you have to start and I have to start. There's no party is dominus litis. It is all about the weighing up of the evidence under oath and then consideration of all the documentation in order to make an informed decision. And very importantly as well, the courts rely heavily on the Section 6 inquiry if that was properly conducted. Dion, there's a couple of sections in terms of Section 10 which might be important. If you could just run us through those.
Okay, so 10.1, the court can at any time subpoena any person to come and testify at court. So that means the banking official or the banks can then be requested to come and testify. Vodacom can be requested to come and testify, or whatever person the court deems necessary to come and give evidence. Any of those people can then obviously be called to come and testify. If there are any problems as far as key and contact is concerned, then in terms of Section 10(1) capital A, the court can then employ the services of the family advocate that can do investigations on key and contact, especially if the father says, yeah, but I'm willing to pay maintenance, but I can't see my child. Then the court can bring an application or can order that the family advocate's office investigate key and contact and
become
assist,
involved. Yes.
Yeah, and assist the parties with a parenting plan. 10.4 is important, that no person that is not supposed to be there shouldn't be there, and can the court is like in camera during these proceedings, because in terms of the popular legislation, the bank statements and all of that is privileged and therefore not supposed to be made known to others. Please note
it's not like the Domestic Violence Act that actually says you can have 3 supporters for the applicant and for the respondent that could assist you or accompany you and support you during that. The maintenance proceedings, specifically as you mentioned, in terms of the POPI Act, because I deal with sensitive financial information, it is done in camera. So no one that is not allowed in court or has no bearing to their two will be allowed in the court.
Yes, if they should feel that they want to have a court supporter, they'll have to bring an application, but it's not prescribed in the maintenance legislation at all that you can have the number of court supporters that you have in domestic violence legislation. That is unfortunately not being catered for, but maybe that's something, Eugene, we should look at. In a case where there's a domestic violence applicant then and there's a later maintenance proceedings, then we should consider maybe bringing an application that she then have that same assistance that she would have had in the domestic violence application also there. I know we are running out of time. So the other most important one that I feel is important is as far as Section 10.6, that matter must be concluded as speedily as possible. In case not, then an interim order can be issued by the court in a case where the case is not finalized after the first appearance of both the respondent and applicant.
Fantastic. I'm not going to run through most of the case law. Most of the case law, all the case law will be in the resource folder, but I can just mention there's no onus of proof. We've referenced the Buch versus Buch case, and the presiding officers that should not take an active or a passive role. They should be actively involved into that, and there needs to be a full disclosure. The Whiteley case, these case law. This will all be in your resource folder with regards to what's happening in a Section 10. Dion, I have one question that came in via email, and this was not a serious one, but it was a interesting question. And I'm briefly going to read that. It says that when a Section 6 application is completed by an applicant, but for instance, the matter takes like a year before going to trial, obviously the expenses are increasing and the applicant's financial position have changed. How should this amended figures be presented? I asked this specifically as the magistrate in Somerset West struck a matter off the roll as he required the applicant to have completed another Section 6 application with her amended figures. Otherwise, she was bound to only work with the figures she presented right in the original application. After the applicant waited for a year for a trial date, she then had to wait and start afresh by order of the magistrate, and again had to go through the whole Section 6 inquiry and the process. This really does seem like a problem that some of the courts or applicants are facing. You know what, they lodge an application, so much time have lapsed, they have been to court for 10 or 12 times, matters been remanded all the times, and then their financial situation has changed. How do we remedy that? How do we solve this problem? Okay. I know what the answer is, but I want to hear it from you.
I hope it's the same that what you are thinking of. The one way I always tell people is to look at lying in expenses in the sense of from the date of birth till the date of the inquiry, then the court is supposed to look at all of that information up till that specific period in order then to calculate what is the specific needs. If there's amended figures that should be presented, that can be done in terms of the bringing it in on a supporting affidavit or supplementary affidavit where you bring that information. It's not necessary to now start the matter of the court. That way you're not acting in the best interest of a child. Luckily, right. Also the SA Law Commission paper in Chapter 9 deals with recovery of money or funds during a period that led to the delay in attachment process. That is not brought in the Section 6 or Section 10 inquiry, where you can adjust the figures, adjusted figures that they speak about in Chapter 9 of the SA Law Commission paper 157. So that's where I would like it to go, where we have those adjusted figures just being brought in. Viva voce evidence is presented on it, so why can't the court accept it? So where a magistrate struck a matter of the court or is not acting in the best interest of the child and is not complying with Section 10(6), making sure that that case is expeditiously being set down and finalized in court. So that's where I would have gone with it. I'm not sure if the lying in expenses was the one that you covered, or is there something else you were thinking of?
No, that was actually perfect. The whole idea of I mean, they alluded to there in Chapter 9 of the Law Reform Commission's paper, but that is just proposals to the amendment of the Maintenance Act. It is actually not enforced. Yes. But in practical terms, what I've seen happen in court, like you said, 100% correct, is that a supplementary affidavit has been filed to submit to court, even if it's a day or two beforehand. Usually if there's another attorney which is also involved, if there's an opposing attorney, then give them a copy as well. Do not give them the opportunity to ask for a remand. So the idea would be, if you are acting on your own behalf or on your own, you are not legally represented, but the father or the respondent has an attorney, and you want to amend the figures, a day or three beforehand, file the affidavit at court so that the maintenance officer will have that at court, and file a copy thereof on the attorney as well. Just go to the office, give them a copy, and have them sign your copy that they've received it. In that way, they cannot come to court and say, but you know what, you've made changes to the documentation. We need some more time to consult with our client. You know what?
Yes.
Section 10.6 is very quite clear. You know what? It should be handled expeditiously. It should be limited in duration and in time. So that would take away their excuse of just asking for a remand. So 100% correct. The answer would be then is to file a supplementary affidavit. And in most instances, that would suffice. Dion,
if I can ask,
yes,
yes, I want to just make sure that I get it out there. Please read paper 157, chapter 9. It's clear on the recovery process, especially if you bought an attachment and then the year amount increased over a few months while the investigation is done. Chapter 9 of the paper 157 of the Law Commission is clear that the court can adjust those figures, but those adjustments have not been brought in section 6 or section 10 inquiries, and that's where we need to maybe tap Eugene back into the Law Commission and tell them, can't we have that adjusted figures also for section 10, especially if the section 6 took years to complete, and then 18 months later when the section 10 is being done, there's so many changes in the financial circumstances of the applicant that figures is outdated. Why can't we adjust it in section 10 to similar to what chapter 9 says we can do in the civil attachment process?
That's definitely thing that we could take up with the Law Reform Commission. That could definitely form part of our discussions with them as well. For those interested, I will be making available a copy of the financial disclosure form that was mentioned earlier by Dion, as well as the Law Reform Commission, the paper 157, that will also be available under the resource section of the website. And that basically brings us to the end of our session today. Advocate Reuters, Dion, colleague, thank you so much for your time and your effort. We really do appreciate it. Thanks you so much for all your insight. It was really great talking to you. I love the interactive discussions. The viewers, the attendees, they also like that. The comments that we had, the floods of emails thanking us for what we do and for how they understand it now properly. It's much appreciated. Again, Advocate Reuters, Dion, thank you so much for being here and for sharing your knowledge so freely with us. We'll be back next week, same time, same place, with a new the session of Lunch and Learn. I simply can't remember offhand which one it will be, but yeah, that's next week's problem. Enjoy the rest of your weekend, and Dion, thanks again once a million.
Thank you, Eugene, and thank you for all our listeners.